Good evening, ladies and gentlemen. Welcome to another edition of Democracy and the Rule of Law, a show where we delve deep into the critical issues of law, politics, and governance. In today's episode, we will look at two critical issues that have made headlines throughout the week. First, we will look at the issues surrounding the seizure of 3 Nigerian aircraft in France and Switzerland, respectively. Of course, the background of the issue arose as a result of an arbitration award against the Ogun State government and Nigeria because of an issue involving the Ogun State Free Trade Zone, a contract which was brokered sometime in 2001 between the then government and a Chinese firm to manage the Ogun State Free Trade Zone. Of course, series of government has come and gone, and there was allegedly a breach of contract by the Ogun State government, terminating the agreement without recourse to the terms of the agreement. The Chinese company has gone to court, several courts, and eventually they got an arbitration award which was not settled, and as a result, they have executed and seized some of the assets of Nigeria in France. And of course, that has made headline throughout the week. A lot of critics, have attributed the issue as to failed governance and lack of adherence to rule of law. In fact, the former presidential aspirant, His Excellency Mr. Peter Obi, has described it as a rascality of leadership in the system that have led to this national embarrassment. So we'll look at the issues surrounding the seizure, the international dimension, and all of the surrounding issue concerning that. Secondly, we'll also take a look at domestically at the recent nomination of the Justice of the Supreme Court, Justice Kudura Kekere Eku, as the substantive. Of course, he will be taking over from the present Chief Justice of the Federation from the 22nd of this month, who has meritoriously served for a broken period of 70 years now. So these are the two topics we'll be looking at in today's episode. We have our guests who are already in the studio, seated and ready, to take us on these two issues. We'll go on a very short break, and when we return, we'll introduce our guests who are already seated this evening. Stay tuned. We'll be back very shortly. Welcome back. Here on to your favorite program, Democracy and the Rule of Law. With me this evening is Barrister Obiora Ume, a legal expert practicing here in Lagos. Barrister Obiora, welcome you to today's episode.
Thank you very much, and good evening to our esteemed viewers.
All right, and also we'll have Barrister Deji Olale, of course, also a respected legal practitioner who have always obliged us his presence whenever he is called upon. Barrister Deji, we welcome you to the show this evening.
It's always a pleasure to be here. Thank you.
Okay, so without much ado, we'll just go into the topics of today's episode. For the first topic, we'll be looking at the issue of the presidential jets, which cost Nigeria an arm and, of course, a fortune, to acquire. Incidentally, which has been confiscated in faraway France, in a foreign jurisdiction. And of course, many people have raised eyebrow as to what led to this. Some have called it rascality in governance, and some have attributed it to lack of adherence to the rule of law. So, Barrister Deji, what do you have to say in all of this?
Well, thank you very much for the opportunity to make contributions on that. It's not a new development. We're just coming out of the P&ID incident, which cost Nigeria so much. But thank God that was dealt with ultimately, legally also. But this one is coming against the background of the attitude of most of our governments and civil servants, in contracting, in entry into foreign investment agreements, bad contracting for Nigeria. You remember the case of the Ajaokuta also that of the Okumoku, also that of the we have a lot of such bad contracts all over Nigeria. Most of these contracts are signed by people who knows nothing about contracting, about legal clauses. Most times when those contracts are signed, you find that lawyers are not even part of the panel. Usually they will send civil servants to execute some of these agreements. But in this particular case, the Ogun State government had an agreement with Yongshan company, a Chinese company, under the bilateral investment treaty that Nigeria signed with China. And it was that bilateral agreement that the Chinese company leveraged on. The original Chinese company, where the problem came up, why I say bad contracting, was that Ogun State government signed an agreement with Yongshan. Unfortunately, Yongshan could not perform the contract. You know the way these Chinese people work. The contract was switched to another company, Zhongshan. And the government did not discover that it was another company that was actually executing the contract at that time. And I think by the time and all that they did was just a perimeter survey of the land, okay? And thereafter, it was discovered that some of the elements of the contract were fraudulent. Even the executions were fraudulent. And so, the government that came in, I think it's the government of Amosun, His Excellency Ibekule Amosun, that came in and wanted to renegotiate the contract, and everything went awry. And thereafter, those issues were raised. The issues of bad contracting, the issues of the fact that they did not comply with some of the provisions of the agreement, and all of that. And the agreement was terminated. And it was at that point that the problem erupted. Originally, the company filed a suit in Nigeria, but because under the bilateral investment treaty, they needed to go to arbitration, since there was an arbitration agreement in the contract. So they had to withdraw that suit, and then they went later to arbitration outside the country without initially notifying the government and all of that. And of course, because when I went through the judgment, you will discover that the handling of the arbitration was even faulty by Nigeria. Some of the issues canvassed were not issues they ought to canvass. Some of the problems they should raise in defense of the state was not the issues they raised. And of course, the U.S. District County Court gave judgment against Nigeria on the grounds that there was no immunity. They raised the foreign sovereign immunity act in the U.S. But we didn't. The court did not accede to it because the American government practiced a restricted immunity, whereas Nigeria practiced an absolute immunity. And the court said, no, you can't claim immunity because this particular contract is of a commercial nature. And where government enters into commercial transactions, they do not have immunity. And I think that was why the award went the way it went.
All right, thank you very much. So, Barrister Obiarobe, Barrister Deji has raised an important issue about contracting.
Yes.
You know, of course, we saw the issue of P&ID case, and we are seeing another issue. The P&ID case would have cost Nigeria a fortune, if not that we were saved at the last lap of that case, even when the award has already been given by the arbitration court. Now we are faced with another issue. Unfortunately, we are not that lucky. Through presidential jet that cost Nigeria and Amana a leg has been seized already. So what do you have to say concerning this?
Well, I believe that the presidential jets will eventually be released. That is my own take. And why do I think so? First and foremost, the contract entered into was between the Chinese company and Ogun State government. The federal government is not a signatory to that agreement or contract. And we know that ordinarily, where there's a contract, is binding on the parties thereto. And then when we look at the whole thing, the original party to that contract could not, perform like my brother and learned friend said. And then two other Chinese companies came up claiming to be the authentic successor to the other original party to the contract. And that issue was not resolved finally. So now, it is this other Zhongshan company that came forward and then started asking for compensation. First, the issue of who is entitled to benefit from the contract is yet to be finally legally resolved. You see, the law is very clear that it is only a party to a contract or its agents that can, or previous that can benefit from the contract. Now, the original party has not informed the other party, the Ogun State government, that this is our successor. And of course, if there is such a thing, there also be a proper documentation of it. That, to my knowledge, was not done till today. Now, when at the end of the day the contract was, halted, terminated, or couldn't fly, they went to court. And they couldn't make headway because, like my friend said, the original agreement had arbitration clause. Then they proceeded for arbitration where there was a award of $55.6 million and $75,000 for legal costs, fees of arbitration, moral damages, and all that. Now, these orders were made, and the Ogun State government is saying that they were not duly served with the processes that led to the orders that were made. And we know that if in fact there was non-service of the processes that led to the judgment, the whole thing will crumble. Because service is fundamental. Without service of originating processes, processes, arbitration processes, whatever may have been done, no matter how excellently done, will amount to nothing. Because it cannot stand on anything. Like the Reverend Lord Denny will say, you cannot put something on and expect it to remain. So the government of Ogun State is saying that they were not notified, they were not served with what eventually led to the orders that led to the seizure. And another very fundamental thing is this: you entered into a contract with Ogun State government, which has capacity under the law to enter into contract with anybody, be it individual, government, or agency. Now, at the end of the day, it was the jets, three presidential jets of the federal government that was attached. Now, how do you now attack the property of someone who is not a party to the contract? You don't do that. Apart from that, there's another issue, fundamental also. The presidential jets that were attached were used solely for sovereign purposes. And under international law, such aircraft can never be attached, and that is so replicated in French law. Under French law, those things have immediately attacked to them. So why would they go ahead to have attached aircraft that are protected by law, by international law, because there is immunity because of the use of which they are subjected to? So these are things that by the time our the lawyers intending that to go into the matter, we raise these issues, will go a long way. You can't attack what is not attachable under international law, and it applies to French law. And you can't also not attach something that belongs to a party that's not a party to the contract.
Yeah, but by Soberman, will you trust the when we look at what has happened in the past and what is happening now? Would you want to trust that these contracts, that have led to this whole thing would have been properly drafted? Because from the fact available, court in UK has even given judgment against Ogun State and Nigeria. Don't you think that the content, because he has mentioned bilateral investment at which they took advantage of, which was an agreement between Nigeria and China.
Yes.
Which, of course, we do not know how they drafted and co-opted Nigeria into the agreement between the state government. Doesn't that this whole issue, give credence to the fact that the government institutions need to pay more attention to while entering into commercial contracts?
I agree entirely that when it comes to contracts, whether they are the one from Nigeria, between Nigeria and any other country, or any government in Nigeria, state government, local government, whatever, and any other party, local or foreign, there must be clearly defined terms of that agreement, and it must also be clearly reduced into writing. It must be clearly written, and all the terms, conditions clearly spelled out. I know that in some cases in Nigeria, some of our people, in the bid to hastily conclude things, may not have paid adequate attention to agreements. And in most cases, when things go wrong, you may see loopholes here and there. I know that could be possible. But, you see, the fact that there's a bilateral agreement or treaty between Nigeria and China under which this thing was done, now the proper thing in circumstances is for those that were involved in the preparation of the agreement to have taken time to clearly define who does what, the obligations and the rights of the parties. But like I said earlier, in as much as I agree there could be, inelegant draftsmanship of the agreements or documents that are related to that project, we still need to go to the fundamentals. The fundamentals are the foundation. The government had an agreement with a party, and someone who is not a signatory to that party, a company, not a signatory to that contract, is the one that had gone forward, had gone to court. I don't know fully what led to the judgment being awarded in UK and so on, but we need to raise the issue of who are the proper parties to that contract, on the issue of contract, because it is worldwide. The principles of contract,
privity of contract,
that it is only a party to a contract that can sue on that contract and can be sued on that contract.
Okay.
Yes, there are few exceptions, but those ones do not come within the confines of this particular transaction. So it is not just enough to say, well, judgment has been given or award has been made. We still need to go back to the basic, to the foundation. Has the party that entered into this contract given any power or authority to this other company to go ahead and represent it? Is it an attorney? Is the company representing the main party to the contract? Or upon what legal grounds has this other company come forward to start making claims on this contract? So you discover that when that issue is, properly ventilated, because it's germane, it's foundational. We also look at the issue of denial of services, of the processes, the notices and the arbitration proceedings, and the issue of the judgment. When the former governor of Ogun says Ibinkolo Amosu came forward, he said they were not even aware, they were not served with some of the documents and processes that led to the attachment, to the court orders and attachments. Now, we know that by law, if there is a process that is meant to be served and is not served, it renders whatever may have been done irregular, not just irregular, but null and void.
Well, let me make some information and clarification based on what my friend has said so far.
Okay.
Number one, the processes of the attachment was done ex parte. It was done ex parte so that it can be spontaneous and the properties can be attached, as under the international rules. Okay, that's number one. Number two is that the question of whether the bilateral investment treaty signed by Nigeria was so nebulous that it allows, it puts Nigeria under duty and responsibility to protect all Chinese investments in Nigeria. In fact, it has a continuous duty. Nigeria has a continuous duty to protect all Chinese investment in Nigeria, which is an aberration. All right. So, and I think that's what one of the clauses where that the companies were leveraging on the question of who essentially is the party to the contract. That Nigeria has, and it was one of the issues mentioned by the U.S. District Court when the matter went on appeal, to say that, look, since you have signed an agreement for continuous supervision and continuous assistance.
So Nigeria becomes an agent of China.
Exactly. You get the point that I'm making. So any company, any Chinese company that is operating in Nigeria has a duty to ensure that they are fairly treated and that nothing goes wrong, which is an aberration. And we signed that contract. We signed that bilateral investment treaty. That's one. Yes. Secondly, Nigerian government, not directly, through the Nigerian Export Processing Board, also guaranteed the contract. So, and that's a federal government institution. So that's also the angle that the Chinese people are leveraging on against the federal government in this situation. But I think the
issue of who entered into this contract.
I think that is the major issue.
Who entered into this contract? Because if you are not a party to a contract,
no contract.
Yes, there's no privy to a contract
with the government. With the state government.
Yes,
Nigeria.
Yes, and to that extent, they don't have any business enforcing the provisions of a contract that are not a signatory to. They are not a party to.
I think that's the only point we can leverage.
That is fundamental.
The question also.
That's fundamental.
The question also of the legal status of those assets that were attached, which my good friend had rightly mentioned.
Yes.
The question of the immunity
they cannot be attached under international law and under law.
So how does this seizure impact Nigeria's diplomatic relationship with France? Because these are country to country. Of course, there's ought to be some level of diplomatic arrangement between both countries. So
I think the problem we have is that Nigeria also has the foreign enforcement of judgment treaty was also signed by Nigeria. So, and that makes it possible for France to execute any judgment against Nigeria from within its own body. In other words, recognition and enforcement of judgment against Nigeria can be done by France. And in matters like this, usually most of these advanced countries will not look at diplomatic issue. They don't see it as diplomatic. They see it as commercial and transactional or contract. And funny enough, just like my good friend, but just before he comes in, one of the judge in the district council and the district court in the US actually observed that there was no contract.
Yes.
In the judgment, if you read the judgment, that there was no contract. But because the US law allows for matters that are of commercial nature, whether or not it is contractual, to be enforced. Awards that are of commercial nature, whether or not they are contractual, to be enforced. That was the reason why the judge, upheld the award.
And that is the reason why that award should be nullified. Because what the people are claiming is based on an agreement. Nobody just call me to say, give me compensation, give me wages. Nobody does that, except you're saying there's something between us, which is the nature of a contract. And the party that entered into a contract, or the party that is making the claims. And our law is not identical with that of US. Now, is still the main issue to be looked into is, since even the judge made a consider that there was no contract, in the absence of a contract, upon what basis will an award be made?
So the issue,
and if you are saying there's a contract, who are the parties to the contract? The original party is not the party that is coming forward to claim, and there's nothing to show that the news company now has taken over the liabilities and assets of the other company. To that extent, this party that has made this thing has no basis in law, has no legal basis to have gone to start making claims.
But the issue now is who nullifies
again, the award is still provisional award. No, the attachment rather is still provisional because it was made ex parte. Now, our own legal team will now go and file necessary papers on why that attachment ought to be set aside as a matter of urgency.
Yes,
and one of the grounds, like I said earlier, is that those aircrafts cannot be attacked. They have immunity under international law of attachment.
Yes.
So that is why I say when I said that those presidential jets will eventually be freed from that attachment.
But apart from the attachment, now the award has been given in about 3 jurisdictions now. So what are the processes? Because obviously international law, they took the arbitration. Nigerian law doesn't govern this particular contract.
Yes.
They entered. They took it outside the shores.
Yes. It's regulated by international law and international.
So what is the process now that this court has given? Who would set aside this arbitration award? Is this still subject to because you said the appeal court has already even given judgment on this arbitration award? So what is the next step?
The position is this.
Because even if we get this attachment based on the issue of sovereign immunity of those aircraft, it still means that our assets in foreign jurisdiction are still in jeopardy. They can be attached at any time.
Anywhere. Now, what they need to do is to set aside the appeal or the award itself. Okay, and different courts gave that judgment. There is a different court that gave the award, and it's a different court that they appealed to. The U.S. court, as a matter of principle, because the U.S. is a common law jurisdiction, under the conflict of law rules, it is the lex fori that determines the legal issue, the treatment of the legal issue, or the adjudication in respect of awards of either a case or in respect of an arbitration. So that's why the U.S. court applied the law of the U.S. in respect of the award. So what they need to do now is to go back to that court and set aside the orders and the judgment of that court confirming that award. They should set aside the order confirming the award itself, and that will relieve Nigeria. It's not just enough to go to France and contend the recognition and enforcement process there. They have to also go to ensure that the award is set aside, or the confirmation of the award by the U.S. court, which are giving validation to these different seizure all over the world, is set aside. Once that is done, then Nigeria will be off the hook. But as it stands today, that order is still there, the order of the U.S. court, and they can leverage on it in other jurisdiction on our assets. So I think that those who are the legal team should not just concentrate on the French incident alone, but they should also ensure that the award is set aside so that such incident cannot occur again in other jurisdiction.
All right. Okay. So by so how does this, now that we are talking about foreign direct investment into the country?
Yes.
So what do you think will be the perception of foreign investors with this whole situation involving this Chinese firm?
Yes, I believe that it is giving a somehow negative impression to foreign investors that Nigeria may not be a good place to invest, but that actually is not the true position. Nigeria is one of the best countries to invest.
Best destination.
Because we Nigerians by nature are a very hospitable set of people, And they assist foreigners even to the detriment of their government and their people. So Nigeria is a good place to invest. But then, looking at the scenario, what is on the front burner now, I believe that the first thing to be done is to go and set aside the order of attachment, the ex parte order, so that those jets will be freed. Because under French law, they are not attachable. Under international law, they are not. That's the first thing to be done. Once those ones are done, then, like my friend and brother said, the next is to now go into the main issue, the issue of the award, the base of the award, and attack it from its foundation. That, the former governor used the word that the company is an impostor. It's an impostor. That the company that is making this claim is not entitled to any claim. When that is addressed, properly addressed, I believe that Nigeria may get out of the entire hook. But then, yes, but then it's necessary for Nigerians, when entering into this kind of contract, any contract at all, to ensure that due process is followed, that everything is properly done.
All right. So what will you suggest the government to do going forward, so to prevent occurrence of this kind of?
In Nigeria, we have a penchant for Chinese companies, and we should be careful of Chinese companies. Why many governments prefer Chinese companies is because of the way they do business. They do their business with official corruption involved. They are ready to bribe governmental institutions to get contracts, to push it. And Nigerian government likes such people. And that's what happened in this case. Okay, and as long as you keep, and the Chinese people they are not fools. In fact, if you want to look at it, some of the best international investment lawyers are Chinese legal experts. So when they are going out to contract, it is a matter of life and death to them. They make sure that there are watertight clauses in those agreements they are signing. It's only Nigerians that don't look at the terms of the contract. Some of those agreements will not be given to them ahead. They just, when they get to the a day before, they will give them box of documents to sign. And because, just like my good friend said, because they want to conclude the transaction, they sign. Most of the time, you find it is civil servants that are sent, or even governors who don't know anything about investment clauses, investment agreements that sign. That's why we get involved in this kind of, we enmesh ourselves in these troubles. I think the time has come that those who are going to negotiate contracts for the country should be legal experts, should be people who knows about international investment law, not just all kinds of characters that we are having now that goes to transact business. You know, the Ajakuta problem is still with us till today. Okay? So we have a lot of such bad contracts and we cannot continue that way. Now, most of the things these Chinese companies do in foreign countries, in third world countries, they cannot even do it in their own country. In China today, official corruption is death sentence. You are executed. Official bribery is, but their government still permit them to do it in foreign countries so as to get business, and that's what China is leveraging on. You remember the case of the railway contract that we had during Amaechi's tenure, where Nigeria's sovereignty was signed off, and the Chinese always like you to sign off your sovereignty in the event of default of your contractual terms. And I think that's what happened even with this bilateral investment treaty that we signed with China. There's a need to revisit it. There's a need to review it. Some of the clauses in that agreement does not benefit Nigeria. So that's just what I want to say.
All right,
it is important, yes, that Nigeria should be worried about contracts with China because they are a very subtle set of people. I recall in the recent past that Chinese people were even asking for permission to build a police station in Nigeria.
Yes, they have one in Botswana.
They want to build a police station in Nigeria. And you see, when they come subtly, they try to take over.
Even in our institution,
yes,
there of faculty to learn Mandarin.
Yes. There are places in there are even some restaurants in Nigeria here that only Chinese people are allowed to enter in Abuja.
Yes.
There's a Chinese town and so on.
Chinese schools.
Yes. So even in Ilupeju here in Lagos, there's this restaurant, a supermarket where only Chinese people enter. No Nigerian is allowed to enter there. So we need to be careful because they don't take anything for granted. And then when you look at the loans that Nigerian government is getting from China, we need to be extra careful about it so that at the end of the day, we don't sell off, we don't mortgage our future to China. We need to be very careful, and in preparation of documents, I don't need to be hasty about it. Take time to read through it and make sure that all the I's are dotted and T's crossed, so that I don't, we don't find ourselves in a situation that looks like embarrassment to the nation, international embarrassment.
The president could have been left stranded if he was accompanying those planes.
And it's one of the new jets also.
Yes.
Wanted, the new
Yes.
jets.
Yes.
Okay, what they say is enough for the wise. We need to do our due diligence while entering into any contracts at all, let alone that with Chinese investors. We'll go on a very short break, and when we return, we'll look at the second topic for today's episode. Stay tuned, we'll be back shortly.